and commissions on trades.
So what's in it for you?
Fisher Investments fees are structured so we do better when our clients do better. When it comes to helping clients achieve a comfortable retirement, we're clearly different. Visit FisherInvestments.com to find out why investors like you switch to us. Fisher Investments, clearly different money management.
Investments in securities involve the risk of loss.
8:07. Let's check the roads in the Team Hochberg Traffic Center with Jim Talamonte.
Inbound Ryan Expressway traffic is stop and go from 31st Street to the Burns Circle. Delays start at 31st in the express lanes as well. There is a crash at Roosevelt blocking the right shoulder. Your drive time is 23 minutes from 95th to downtown. Outbound it's 14. Now in the downtown area, restrictions have been lifted. Roads, ramps, and bridges are open again. CTA buses and trains are running through downtown. On the inbound side of the Kennedy, traffic's congested. The Hubbard Tunnel to the Burns Circle. 21 minutes, so here to downtown. Inbound Eisenhower, it's tight through the avenues. 30 minutes, 390 to downtown. The Stevenson has some delays. It's 30 minutes, 355 to Lakeshore Drive. That's traffic. I'm Jim Talamonte.
Chicago's Morning Answer continues next in our 1 hour heating and air conditioning weather center. Sunny and 90 today. Clear and warm, a low of 70 overnight. Currently, 70 degrees at O'Hare. Next news at 8:30. Chicago's Morning Answer with Dan and Amy continues next on AM 560, The Answer.
Listen to AM 560, The Answer, online at 560theanswer.com, on the AM 560 mobile app, on your Alexa-powered smart speaker, on TuneIn, iHeart, and radio.com. This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560, The Answer.
Top of the morning, Dan and Amy, and Jim Mad Money Kramer is sort of a buffoon. I mean, he's a smart guy and he's a successful guy, but he's sort of a clown show, too, and I get that,
part of his shtick, like that's his.
Well, thus the Mad Money, and I get, and his, morning zoo crew type style for his show, talking about stock picking and whatnot. But look, when you're right, you're right, and sometimes he is, and I'm not talking about stock picking, I'm talking about general commentary on economic policy and what you see happening as a result of the policies that were chosen, specifically the lockdowns. He's been pretty solid, and he was again last week offering this perspective.
It does peter out. It's kind of musical chairs. How can the market rebound without the economy? Because the market doesn't represent the economy. It represents the future of big business. The bigger the business, the more it moves the major averages. And that matters because this is the first recession where big business, along, of course, with bigger wealth, but that's not really my show, is coming through virtually unscathed, if not going for the gold. Small business, the ones that aren't publicly traded, they're dropping like flies after a government-mandated shutdown because they're non-essential. And the people who work there are non-essential. It's hard enough to run a small business. How about when the government says you're closed and the landlord says, I don't care? That's the thing about this pandemic. It's been one of the greatest wealth transfers in history, and it's a wealth transfer that was mandated by the state. I think that it'll have a horrible effect on our country.
One of the greatest wealth transfers in the history of America, mandated by the state, and it's a wealth transfer from the have-nots to the haves. We've said this for weeks on end. Wait till you start to feel the economic impacts of the policy choices. We knew who was unemployed, 40% of the unemployed making less than $40,000. We knew who the winners were, big tech and big government, and those people who are somewhat recession-proof, although a bunch of employees at BP found out today that they're not recession-proof. It sounds like 10,000 layoffs announced.
That's huge.
I assume probably a lot of executives as well. But what Joel Kotkin calls our neo-federalism, and it's a real problem, and we're just at the beginning of it, which is why a jobless recovery is not a good recovery. We need a recovery that features people getting back to work and getting on with their professional lives. For more on this, pleased to be joined by Joel Webber. He's a Chicago area attorney. He was an executive at Whirlpool and GE, and he is hosting a free COVID-19 liability prevention briefing. Info is available at managinglegal.com. Managinglegal.com. He wrote a piece in the Wall Street Journal. And the headline: Will lawyers act with honor after COVID? I read the headline and I just laughed and laughed and laughed. And then after I got done with the chuckle, I read the rest of it, and it's another aspect of what we've been talking about, what Senate Majority Leader Mitch McConnell has been talking about. You need to make sure business kids can get back to operation without being beset by trial lawyer directed litigation. Joel Webber, thanks so much for joining us. Appreciate it.
Good morning, Dan and Amy.
Good morning. Will lawyers act with honor after COVID? I don't know if we can trust them to do so on their own. So do you support what McConnell and others have talked about, some sort of liability protection, some sort of indemnification?
Yes, absolutely. Nobody has come up with specific, very detailed proposals along those lines, but the general idea is to provide a safe harbor set of rules, and if the employer, vendor, retail outlet obeys, the masking and the distancing and whatnot, then they can't be sued for negligence. They could be sued for gross negligence or reckless behavior or for intentional harm. But that's the general outline.
Do you think that's why some schools are fearful of opening, because if one kid dies or brings something home to their family that they might be sued, that there might be possible litigation?
Absolutely. I mean, part of preparing for this interview, I looked at all the recent stuff, including, just this morning, there's 11 new articles on this liability limitation relating to COVID. If you Google COVID liability, and in the education area, there is considerable focus in the higher education, elementary and secondary education. The problem is, if someone comes down with COVID and decides to sue, let's say, the school, as you mentioned, for, I contracted the COVID-19 virus because of your negligence, without regard to fault, before we even think about who did the right thing, who did the wrong thing, that school is on the hook for tens of thousands, maybe hundreds of thousands of dollars for the litigation process, the document demands, the depositions, the motion practice. And that's before you even begin to ask the question, did they really cause it? So it's a tough deal.
And let's go back to what Investotainer Jim Cramer was talking about as well. I mean, who is least well-positioned to weather that sort of exposure? It's not big corporations that have general counsels and the resources at their disposal to fight litigation. It's the small businesses that are already hamstrung.
Yeah, bingo. I mean, because the problem is the small business gets that summons and complaint served on them, and they have to immediately go into this cycle I mentioned. They have to file responsive pleadings. They need to respond to document demands. And by the way, all that the lawyer for the plaintiff needs to do is know the magic words, if you will. I mean, any lawyer with a rudimentary IQ can draft a complaint alleging negligence that'll survive a motion to dismiss. So you're in for all that document demands and depositions and whatnot before you even before the court even begins to consider who's at fault. Was anyone at fault? Well, yes, that is exactly true.
And by the way, as somebody who has a law degree, my experience is all lawyers have a rudimentary IQ, as it turns out.
Well, what about, I know a lot of moms, we would be willing to sign any waivers or contracts saying we will not sue if we can just get our kids back in the classroom. I'd sign one to go to church. It's just, we're willing to do it. Do you think it would come to that?
Well, it's interesting. I'll speak to it this way. One of the ways that that's being addressed is, for instance, Disney World has announced on their website that if you enter our park, you are, by entering our park, expressing that you're accepting the risk. There are other retailers and institutions that are having, as you're referring to, Amy, a written waiver, and so this is the problem. Lawyers and legal institutions really resist being pinned down, and so if it were possible to sign a waiver and have it stand up in court and know that it would stand up in court, certainly that would give me a lot of comfort advising a small business. The problem is the courts then look in back of the waiver, and the plaintiff's lawyer will say the waiver was a contract of adhesion or some other lawyer speak for the proposition that we want our second bite at the defendant. So you're making total sense. I've always thought this about medical liability. I've always thought I don't want to sue my doctor. I want to talk to her about my medical condition. Right. I would sign any waiver if it reduced her malpractice premiums. But the legal profession, when major efforts are made in that direction, sometimes the legal profession has succeeded in getting them overturned in court. So right now, what you're talking about is a great idea, but a jump ball.
Yeah, we know that in Illinois, where you've had tort reform overturned by the state Supreme Court, no question. You write in your journal piece, if companies can pivot and doctors and nurses can risk their lives to help, we lawyers should be able to dial back our greed and put our country first. And I wonder if you have had any ARDC complaints filed against you since you wrote that sentence.
Not yet. The only thing along those lines was one of the comments to the post that was made online. Someone suggested that an article in the Wall Street Journal suggesting that lawyers might behave honorably. He didn't know whether he was reading the Journal or the Onion.
Yeah, that's true.
We lawyers, I don't want you to speak for all lawyers. I certainly can't. But one of the things that's always bugged me about a profession for which I have great respect and that can be a very great fiduciary effort, the legal profession gets pretty self-righteous about what makes them money. And so instead of saying, well, we want this rule because it protects our marketplace for exploiting the tort system, they will say this is the effort for justice and we're up for the little guy. So it's very hard to have a non-emotional discussion about this.
Are there any bar associations that have moved in this direction to try to be constructive, as you're suggesting?
Short answer, no.
Right.
I read the media every morning. I go looking for this. I even am reflecting on the Twitter sphere with respect to lawyers I respect. And apart from a couple of people who are well-known, tort reform advocates, the bar is just, as I said in the article, silent.
Mm-hmm. Well, I love the last line of your piece. We lawyers should be able to dial back our greed and put our country first. That's good.
Well, I appreciate that. I believe that. I got to tell you, that line came from a friend of mine, and I endorsed it. We lawyers, and again, I don't mean to speak for all lawyers, but there's a certain tentativeness and theoretical quality the way we like to talk about things. And that's the point is, look, the doctors are giving up their safety and they're changing the way they put people into hospitals, and these companies I mentioned in the article were retooling to completely different product groups in order to help the public. The legal profession ought to do something comparable. I'm saying they ought to. I'm not going to wager my pay on that.
Right. Well, at least you struck a blow, a rhetorical blow for, the right side here. Joel Webber, Chicago area attorney and former executive at Whirlpool and GE. Free COVID-19 liability prevention briefing available at managinglegal.com. And I should mention, just give you a chance to talk about any details that are important about this liability prevention briefing you're doing.
Well, the point is it's directed to CEOs, business owners, chief financial officers. It's directed to P&L executives, people who run stuff. Mm-hmm. My story is that about 10 years into my career, I accepted a corporate client's invitation to become a business person. They said, we think you can run a division. And so when I changed from the lawyer side of the lawyer-client table over to the business side, that completely changed everything that I think about how law helps and hurts. So the whole point of the seminar is it will use and be up to date on all the latest regulations and court decisions and whatever. But it's not a legal lecture. It's for business people, because ultimately the prevention efforts have to be led by the business people, not by the lawyers.
Well, that's great. It's great that you're doing that. Again, managinglegal.com is where these seminars will be hosted. Monday, June 29th, 11 a.m. Central Time, and Tuesday, June 30th, so the end of the month, 2 p.m. Central Time. Monday the 29th, 11 a.m., Tuesday, June 30th, 2 p.m. Joel Webber, thanks so much for joining us. Appreciate it.
Thank you, Dan and Amy. I appreciate it.
Thanks. Good luck. And he joined us on our turnkey.pro answer line.
If you're talking about it, Dan and Amy are talking about it. It's Chicago's Morning Answer on